Welcome to the Four Corners 912 project discussion on rules of the game. For a country to exist peaceably as a unified people in the game of life, we all must be playing by the same rule. The rules for our country were established in the Constitution that was agreed upon to abide by. This was and is the supreme law of the land.
To follow the rules, you must know what they are. They are few and clear. We hope to help you all to better understand what the rules are, as we are looking to elect new representatives in local and state government offices next year.
They take an oath to uphold the constitutions of both the state and the United States.
What are they to uphold and protect?
We will begin this regular discussion beginning with the Bill of Rights, which is the first 10 amendments of the Constitution.
Welcome back to the Four Corners 912 discussion on the Constitution. This week we'll be talking on the Fourth Amendment. These are in the 10 amendments, which are the Bill of Rights. Now, before we get started, one thing we need to remember is these Bill of Rights, or these first 10 amendments, are not laws. They're rights that are God-given to us, not made by the Constitution or by man. It's important to remember that. It's just like you're playing a game, Monopoly or poker, you play by the rules. And the Constitution is the rules. We need to play by them. Right, Bud? Now, we're going to go through the Fourth Amendment. Bud, how about reading it to us? What do we got?
The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched, and the persons or things to be seized.
So, where did this come from, and how is it used today?
During the colonial period leading up to the Revolution, one of the problems we had was that the British would issue warrants. They had 3 different kinds of warrants, and most of us never heard of them. The one that was most abused in that period of time was called a general warrant. And it was where the British government or the governor would just issue a warrant to somebody. It didn't have to be a law enforcement. They'd just issue a warrant to somebody. Go search, see what you find. No specificity whatsoever. Go see what you can find. And that led to a great deal of problems. Lexington and Concord, they were going to look for the ammunition in the armory. That's what they were doing. So that was the one that was most abused during that period of time. But they did also issue specific search warrants, just as we just read, that would have the person and places and so forth and so on. So we had those. And the third one that is actually embedded in the original Constitution. It's Article 1, Section 8, Clause 11. Letters of marque and reprisals.
Marque?
Marque. M-A-R-Q-U-E.
I don't think I've ever seen that word, and I don't know.
Probably not.
So what is it?
But it's in there. Now, the definition of marque and reprisals are almost identical. Marque is reprisal. So this could be read letters of reprisal and reprisal. The only nuance I could find was that a letter of marque might have been specific. Letter of reprisal might have been more general. And we remember from our 7th grade civics class about the War of 1812, what the problem was there. The British were seizing our merchant ships and lesser naval ships on the high seas. They would take the cargo, turn it over to the king, and the sailors became impressed into service in the British Navy. Okay?
Are you saying that they consider that legal?
Well, they considered it doable.
Yeah.
So what we wound up doing is we would issue a letter of marque. Now that gave to the holder of that letter the imprimatur of the government to go after that specific ship that had raided our merchantman. And the reprisal would be more general, that, you know, go whatever you find, have at it. Now, what this turned out to be, we might remember the term privateer.
Oh yeah.
Okay, so the British government and the United States government would issue these letters of marque and reprisals, even to private merchant ships, a lot of which, after a while, became armed. You know, put a cannon or two on there. So they would have not part of the Navy. They were privateers because they had this letter from the government that said they could go after the British ship, or the British could come after our ships. And so that's where I think that nuance is as to whether you went after a specific ship or just any British ship. And so that's kind of how I understood letters of marque and reprisals. But one of the problems we had was, okay, privateers were what I just talked about. You know, they had this letter of marque. Whatever they seized on the high seas was turned over to the government. Okay, it was booty, bounty, and so the privateers, some got to thinking, why would I turn this over to the government? They kept the booty for themselves. They impressed the sailors for themselves, and lo and behold, we come up with a pirate. So some privateers actually became pirates. They kept all the booty for themselves. Kind of a little, I thought was an interesting side note.
So we used this during the War of 1812.
Uh-huh.
The colonists at the time, or the American people, we used this.
We did. Not since that I'm aware of. We haven't used it since.
Okay. Today, what does that mean to us today? How does it use it? Do we abuse it today? It's in the Constitution. How's it used?
I could not find any usage after 1812, the War of 1812, for the letters of marque and reprisals.
Okay.
Now, we don't issue general warrants in the United States. Amendment 4 is quite specific about person and things to be seized and all of that there kind of stuff. So the search warrant is supposed to be quite detailed. That's the only ones we use today. Even though, I mean, a letter of marque and reprisal is constitutional. I think if we issued a letter of marque against an oil tanker seized by the British at the Straits of Gibraltar, if we issued a letter of marque to go get that tanker away from the British and away from the Iranians, how would that work? Who's going to do that, right? So
Not.
they're not going to do that. We just we'll play around with the notion of a military action, but it wouldn't be a mark of reprisal.
So let's look at what you're saying is the search warrants are what we're using today.
Specific search warrants, yeah, regular search warrants, what we're using today.
Yeah. And these are abused in any way?
Duh. Yeah, in my personal opinion is that the Fourth Amendment, and in conjunction with the 14th Amendment, are probably the most used in federal court and the most abused in federal courts. We hear these horror stories all the time. I mean, just remember back a little while ago, the raid on Manafort's house, 6 o'clock in the morning, a no-knock raid at 6 o'clock in the morning. They might have had a search warrant that had specificity in it, but it was totally unnecessary, uncalled for, and I would say an illegal raid based on the Fourth Amendment.
If I remember what you just read earlier, when you read the amendment, it used the word reasonable.
Reasonable. Well, it says that the people should be secure against unreasonable searches. Well, guess what the word unreasonable gets us? A matter of opinions.
It's one guy's idea of what is reasonable against, I might disagree with you, what's reasonable.
That's right.
We do that all the time.
We do that all the time.
So here you have a judge giving an opinion, for whatever reason, it is reasonable to issue a warrant.
Yep.
I guess to me that shows out the importance of all of our elected officials or judges. Many of them are not even elected. They are appointed.
Yep.
Making a decision of constitutional importance. And our liberty and our constitutional rights, they can be easily violated on their judgment and opinion.
We used to have a saying, I don't know if we do it anymore, but judges and prosecutors and defense attorneys, they're all lawyers. Okay? Now, we used to have a saying, you ask a lawyer a yes or no question, you'll get 5 different answers. So what's unreasonable to one may be quite reasonable to another. And now, to raid a guy's house at 6 o'clock in the morning, to search for papers that might implicate other people, you didn't have to do that. Now, here's one. How many remember Randy Weaver up in northern Idaho? There was a raid on his place because it was suspected that he had a shotgun that was 2 inches shorter than the law allowed. And that was true. He did have a sawed-off shotgun. And so we wound up with this FBI and ATF raid that cost his wife and his son, wasn't it?
Yes.
They shot his son in the back, shot his wife in the head. Okay. The sheriff was not even informed that this was going to take place. When he found out about it, he said, "What's the matter with you idiots? All you had to do was call me, I call Randy, he comes in and we chat." Okay? But there was a case of an abuse of a so-called search warrant looking for an illegal shotgun. Now, Randy Weaver just wanted to be left alone. And he was actually trapped into buying that shotgun. In other words, he did not know what a sawed-off shotgun would do in under the law. He was unaware of what the barrel length had to be in order to be considered a sawed-off shotgun. He thought it was a nice gun and he bought it. Okay, so we'll never prove that he was set up, but there are those that say he was. Anyway, there's a case where the whole operation was unreasonable from the issuing of the search warrant on forward. Everything that happened there was unreasonable. But we hear of those periodically. But they will always look for, especially the prosecutor, will look for ways to get around this unreasonable search and seizure. One of the ways they do this is called exigent circumstances.
Explain.
What circumstances?
Exigent.
Oh, exigent. This goes back to the no-knock raids, and I think it came about due to the war on drugs, where they would have these unannounced no-knock raids, go in full force, because they had to catch the drug dealer and the drugs before he had a chance to flush it down the toilet. If they knocked on the door and said, "May we come in?" the drugs are going down the toilet first. Now, there again, is that reasonable or unreasonable? Matter of opinion. My personal opinion, unreasonable. You have a search warrant to search for a certain place, certain person, certain things, and you go do that. Now, if the drug dealer flushes the drugs, too bad. You lost that one. Catch him another way. Do something different. But this no-knock raid has turned into a very dangerous situation, both for the occupant and for the police. And I don't think it's worth it. So that's just one example where, in my personal opinion, that's an abuse. These no-knock raids are an abuse of the Fourth Amendment. Now the courts have approved it. That's what we live with. It doesn't mean that it's right.
By doing so, isn't that kind of a violation of our liberty and our rights? It would seem to me you're assuming by the no-knock raid that he's already committed a crime.
That would be true.
Without any due process to going after him.
Yeah, due process is out the window.
It's just, we've already made a decision that you're wrong.
Yep. Now they'll say, well, we presented our case to the judge and the judge approved, so therefore due process was satisfied. No, that part might have been satisfied, but the part about where you go breaking down doors, that due process went out the window. And the other example of how this has become so twisted, and I'm not going to say it's an abuse, but it would be and this is where we really put the police in an untenable situation. So a police officer pulls you over for a broken taillight, and license, registration, and all of that, and he sees a pistol laying on the seat. Can he search the car? No. That car is an extension of his house. Therefore, if you want to inspect that weapon for the serial number, search warrant. No, unless the guy gives you permission. But if he doesn't give you permission, you stand on the side of the road until you get a search warrant. So you're standing there waiting for this search warrant, and you notice that this car matches one that was described in a kidnapping. So the policeman says, can I look in the back seat? Can I look in the trunk? The guy says, no. Search warrant. You stand there until you get a search warrant. The policeman hears a groan. Seems like it's coming from the trunk of the car. Does he need a search warrant? No.
That's an exigent
That's an
circumstance.
exigent circumstance. You need to act immediately based on what limited information you might have. So if you hear a moan and groan coming from the trunk, you pop that trunk. You don't need a search warrant. And the courts have approved that exigent circumstance. Same thing with the no-knock raid against the drug dealer. That's called an exigent circumstance because we have to act immediately based on what we know.
Mm-hmm.
And so that gets into this whole when and where and what business. And, particularly describing the place to be searched and the person or things to be seized. In the case of the moan coming from the trunk, how do you get a search warrant? Specifying the person or thing to be seized. You don't know what's in the trunk.
Mm-hmm. Yep.
So you can't specify. And so you get back to the exigent circumstances again. One of the abuses that we've had here locally is with, and again I mentioned that these search warrants are also defined in the Colorado Constitution, Article 2, Section 7. And so we've seen right here locally what we think is an abuse of the search warrant by the game wardens. Okay? Well, they just think they can come on your property on suspicion of nothing because, well, I needed to check. No, you didn't. If you need to check, you stand on the side of the road of the county road and get your binoculars out. You can do that, but you are violating Article 2, Section 7. If the game warden says, well, I see something suspicious over there on that private property, even though I know that that guy owns that property. He's going to go on your property just to see. Colorado Constitution, federal Constitution. You're violating them both. And yet they do it regularly. So, just another instance where this is not theoretical. This happened here in Montezuma County to one of our citizens in Montezuma County. And more than once, I'm sure, but this one became a little bit into the public realm. So those are the kinds of things that a very simple statement. I mean, Article 4 is one sentence, lots of commas, but it's one sentence. And look at how screwed up it is when we get right down to where the rubber meets the road. It just gets all messed up.
Well, are we covering Fourth Amendment adequately?
I doubt it.
There's a lot to it. It opens the door for a lot of
Yes.
consideration. All of our officers, judges, enforcement officers need to be better informed of what the rights are, what the Constitution of the state of Colorado, Constitution of the United States, actually say about all these issues that they are enforcing and opinioning on, and so that they can ensure that the rights of the individual are protected.
The big issue we have with that is, and our own district attorney has said this, lawyers do not study the Constitution. There's no such thing as a Constitution class in law school. They study constitutional law, which is all of these court cases and judicial opinions, both for and against. You know, they'll use the prevailing opinion when it fits, and they'll use the dissenting opinion when it fits to make, you know, to justify what they're doing. And so we don't study the law enforcement, our judicial system. Don't study the Constitution. They don't study the background. They don't study the history. They study some court case from 1873. Well, a big deal. This isn't 1873 anymore. And they probably got it wrong anyway. So, you know, there's our problem. And the one thing I don't want to put the burden of constitutional interpretation on our policemen. That ain't their job. It's the citizen's job, not the cop's job. Okay? I mean, you want to get into a constitutional argument when you get pulled over for speeding? That's really dumb. But I think that's an unreasonable burden to put on our police force, is to be constitutional scholars. Yeah, they have to know some of these court cases about, you know, when can you pop the trunk? Yeah, they need to know that kind of thing. But those are set out in the rules and regulations of the police department. And they condense all this stuff down and do that.
The burden should fall on our courts and our legislators passing laws that are not pursuant to the Constitution.
That's where it starts. Exactly.
We've had several of those laws passed in our own legislature this year that were not pursuant to the Constitution, putting everybody in a quandary and as you say, the enforcement people in a real quandary. What do I do?
The red flag law is so unconstitutional on so many different levels. You know, it's just boggles the mind. How do you specify in this warrant what is to be seized? You don't know what guns that fella has. Now somebody might know and provide the information, but that's not always the case either. It's just, well, I know he's got some guns over there somewhere. If you can't specify that it's a 38 or a 17 or a 222, then your search warrant's invalid. It says describing the place to be seized, the person or things to be seized. Describing the things to be seized. Well, if you don't know what it is, you can't describe it. So, but see, we gloss over that, all that stuff in our judicial system. We gloss over that stuff.
Well, I'll tell you what, we better move on to our next session.
And
And
finish our coffee before it
finish
gets
our
cold.
coffee. Yeah. And we'll be doing Amendment 5
Amendment 5
next time. In the meantime, if anybody has been watching and had some questions, the address is on our front piece up there. Give us an email and we'll go from there.
You betcha. We'll answer any questions we get.
See you next week.
Maybe.
See you next week, guys.
See ya.